Now, this analysis bears on a much broader conversation about the so-called contrast between targeted and universal remedies. Universal remedies are the ones that rhetorically benefit everyone without getting into all those messy, divisive, and stigmatizing issues of targeting relief to particularly deserving victims of injustice. Within that debate, Teamsters would ordinarily be considered a case of universal remedies. The same principle applies to everyone. Anybody, black or white, who loses a job because of their race is entitled to get that job back. That universality underwrites the appeal of colorblindness formulations of anti-discrimination. But describing Teamsters in this universal way is possible only after having already chosen the baseline in which the employer never discriminated in the first place. Anyone universally is entitled to restoration of that baseline. If only African Americans receive that remedial intervention, it is merely because only African Americans were deprived of the baseline, not because the remedy was targeted at African Americans. Thus, we should be skeptical whether remedial intervention, we should be skeptical whenever a remedial intervention is criticized for excessive targeting and insufficient universalism. Lurking behind that contrast may be an unwillingness to articulate and defend the relevant baseline with sufficient vigor. Correcting the baseline might transmute the targeted into the universal, as I just did with Teamsters. One more comment on Teamsters. Notice how the priority hiring remedy creates a specific intra-group distribution, not just an inter-group one. The court insisted that the remedy for black non-applicants be limited to those who already were local drivers and who could prove that they would have applied, absent the employer's discrimination. Now, in one sense, that was a restrictive rule. It created the risk that a genuine victim of discrimination would receive no remedy because he lacked the evidence to prove the truth that he would have applied. But in another sense, the rule reaffirms the baseline and the restorative nature of the remedy. Not all black local drivers would necessarily have applied for long-haul routes, even in the absence of discrimination. The financial benefits might have been outweighed by other considerations like very different work schedules. Therefore, the court's rule creates an intra-group distribution that concentrates remedies among those black workers who suffered the most from the employer's discrimination and channels remedies away from other black workers who did not. Black workers, in other words, are not treated as interchangeable with one another. This tension between, on the one hand, avoiding excessive evidentiary hurdles when it is impossible to unscramble the egg, and on the other, recognizing the uneven effects of racism, is a deep tension that we see in Teamsters as much as in conventional affirmative action cases. Another intragroup distribution issue comes more clearly into view when we extend the analysis beyond the domain of conventional disparate treatment claims. So here I want to consider U.S. Airways versus Barnett, which is the leading case on reasonable accommodation under the ADA. Ordinarily, this case is read as a zero-sum game between the plaintiff Barnett and one other worker without a disability. Simplifying a bit, Barnett worked a job handling cargo for U.S. Air, but after he became disabled, he could not continue doing that cargo work, even with a reasonable accommodation. Rather than lose his job at U.S. Airways, Barnett used his seniority rights to transfer into a vacant position in the mailroom, a job he could still do. At some point, however, an employee senior to Barnett sought to use his seniority to transfer into the mailroom and bump Barnett out. Let's call him mailroom guy. So Barnett argued that U.S. Airways should let him stay in the mailroom as a reasonable accommodation, thereby deviating from the seniority system. The court accepted the employer's characterization of the case as a conflict between Barnett and mailroom guy. According to the employer, Barnett was seeking preferential treatment on the basis of disability, something that would never happen in an anti-discrimination statute. The court accepted the premise, but rejected the conclusion. Breyer's majority opinion agreed that an accommodation conferred a preference by, quote, permitting the worker with a disability to violate a rule that others must obey. Here, the rule of seniority-based job bidding. But the court then said that the ADA specifies that preferences will sometimes prove necessary to achieve the Act's basic equal opportunity goal. It's a preference, but that's okay. This grudging acceptance helps explain why the court ultimately ruled against Barnett on other grounds. Once the baseline is Barnett versus mailroom guy facing off for the mailroom job under the seniority system, it does look like Barnett sought a preference based on his disability. Absent a disability, he could not seek reasonable accommodation. But why is that the right baseline? The court's gesture at equal opportunity is woefully vague, and it never offered an alternative baseline. I read Barnett this way. Let's roll back the tape a bit, Kim Crenshaw style, and get some historical perspective. I don't mean the grand sweep of history and the construction of the idea of disability and the formation of jobs around certain kinds of bodies, although all that's true. I mean something much more specific to the case, much like the observation in Teamsters that specific black city drivers lacked long-haul positions because this specific employer and union discriminated against them. In Barnett, that means turning our lens from mailroom to cargo, where Barnett started. He lost his job in cargo because of his disability. That's what this case is really about, and that's why Barnett is entitled to seek accommodation. It's not just because he's a guy with a disability, just like the non-applicants in Teamsters did not get priority hiring just because they were black. Were it not for Barnett's disability, he would have stayed in cargo, and mailroom guy would have gotten his job just fine. Once we set the baseline in which Barnett keeps his cargo job despite his disability, now keeping his job by staying in the mailroom looks like a partial remedy for losing the cargo job because of his disability. And at this point, we need to introduce a third character, cargo guy. Cargo guy is the person. Cargo guy is the person who replaced Barnett in cargo when Barnett had to leave that job. When he got bumped by mailroom guy, Barnett still had seniority to turn around and bump cargo guy and keep his job that way. But Barnett couldn't bump cargo guy because his disability made him unable to perform the job. And so the intergroup distributive insight of Whiteness's property is that restoring the non-discriminatory baseline means more than ratifying Barnett's interest in the mailroom job as remedial, not preferential treatment. It also reveals how the discrimination against Barnett redounds to the benefit of cargo guy, who only gets and keeps that job because of Barnett's disability. But cargo guy and his interests are never mentioned in the opinion, let alone questioned. So ratifying cargo guy's property interest in the discriminatory baseline not only facilitates derogation of Barnett's claim as an appeal for special treatment, but it also constructs a narrative of intergroup conflict. If we begin with a non-discriminatory baseline in which disability does not exclude Barnett from the cargo job, then the zero-sum conflict over the mailroom job is not between mailroom guy and Barnett, it's between mailroom guy and cargo guy, neither of whom has a disability. If Barnett stayed in cargo, those are the people who would be facing off over that job. Barnett would be out of the crossfire. But instead, the court's baseline error channels the mailroom guy's grievances toward Barnett. Moreover, if remedying disability-based disadvantage is a cost properly borne by employers, the mailroom guy's grievances should be against U.S. Airways and not against Barnett. Instead of the employer restoring Barnett's baseline by shutting out mailroom guy, U.S. Airways could satisfy both of them by creating an additional mailroom position or by providing the more typical remedy of front pay pending priority hiring. Another way of putting this same point is that if cargo guy's property interest in discrimination is to be preserved, surely the cost of that should be borne by U.S. Airways and not Barnett and not mailroom guy either. So in this analysis, being precise about the non-discriminatory baseline tells us something about intragroup distribution on both sides. So I'm going to wrap up and skip ahead a little bit by making my way back to the conventional affirmative action context. Sorry, without making my way back to affirmative action. Instead, I just want to observe how important it is to have a relatively precise account of what counts as discrimination, an account that's applicable at the level of individual employers. Such an account is implicit in my analysis of Barnett and explicit in other work, in which discrimination involves the loss of job opportunities because of one's protected status, regardless of whether the employer inflicted that loss with discriminatory intent. This understanding of discrimination coheres with some passages at the end of Whiteness's property, such as Harris's endorsement of a distributive justice baseline in which, quote, individuals receive that share of the benefits that they would have secured in the absence of racism, end quote, including racism perpetrated by actors other than the employer in question. Now, that formulation is intriguing in part because it grounds itself in individuals, which in turn is what opens up the space to engage questions of intra-group distribution. So thank you, Cheryl, for pointing the way.